factor here is really what's driving this case.
Derek, that is the only issue in this case. If you're the prosecutor here, you can't give a discount on this case. This is an execution of a police officer, and Tennessee is a death penalty case, and this is a case that's appropriate for the death penalty. So what the defense is trying to do here is to try to negate that premeditation. It's going to be very difficult to do so because of the facts and circumstances of this case. You don't need to lie in wait or any of those other things that hire hitman to satisfy the premeditation component of a first-degree murder charge. But that is what the defense is going to try to do to try to get Wiggins off death row. Evidence. He has Baker's backup revolver. He has his car keys in his possession. There is no way that he is going to be able to at least argue with any credibility whatsoever that it was not him who shot Officer Baker. So he's going to have to somehow try to negate this premeditation. Going to be very challenging for the defense here. Tough case and a very strong case for the prosecution.
So we're on cross-examination here, and it seems like the defense attorney is going through some pictures, wanting to point out the pictures found in the wallet, apparently, of Stephen Wiggins, who was killed. Let's talk about the emotion of this case. I mean, you've got a father, a husband, a sheriff's deputy shot and killed during a traffic stop. I mean, we talk about routine patrol, but clearly nothing's routine when you can get shot and killed on the job.
Derek, incredibly sad case. And we know the prosecution's theme here is because they started with Officer Baker's widow. And she was the first witness in this case. And she described his last day, his last morning when he took that sip of coffee from her mug, and describing their young daughter. Just incredibly sad. I mean, all murder cases are sad, but this one is really something else.
Right, and we talked about the difference here between life and death. That's what this case is hinging on because of the premeditation factor. How can the defense attorney sort of get around the argument that this was premeditated? What would they have to prove?
It's very difficult because there's two sets of shooting. There's initial shooting when Wiggins was in the vehicle, and then when he gets out of the vehicle and unloads the firearm into Baker when he's on the ground and kills him. So it's going to be very tough to get past premeditation. They're going to have a very creative argument or maybe hope for one or two holdout jurors at best. Maybe someone is opposed to the death penalty, but it's going to be very, very challenging for the defense in this case.
Is that the threshold, though, the fact that he, got out and then shot him more as he was on the ground? Is that what we're looking at in terms of premeditation?
I think that second shooting or the second set of rounds that were fired into Baker, that makes it very challenging for the defense. I mean, you're talking about someone who gets out of the vehicle, walks over, and shoots him several more times when he's on the ground. It's going to be hard to argue against premeditation there.
All right. And Neama, I was struck by the fact that they've got a lot of evidence that was found in the backpack of the defendant belonging to the victim here, Sergeant Daniel Baker. I mean, that's incriminating for sure. You got to wonder how the defense attorneys will get around this.
Yeah, what I expect happened here was the defense attorneys were prepared to plead guilty if the state took the death penalty off the table. And that is something they were not willing to do. This is such a heinous act against a police officer and incredibly sad. And it's really a small world. Officer Baker was one of the lead officers on the baby Joe Daniel case that you and I covered here on Law and Crime. And it's just incredibly tragic. So that's the reason this is going to trial, because defense probably wanted to plead, wanted to take the death penalty off the table. State said no. And now at trial with this jury, they're trying to argue against premeditation. It's going to be very difficult. If it was just the first shooting when Wiggins was in the vehicle, maybe you could have argued accidental discharge or something to that effect. But the fact that he got out of the vehicle and then shot him afterwards is going to be very, very challenging in light of the facts and circumstances of this case.
Isn't that a gamble, though, to take the case to trial, hedging on the fact that maybe a jury may not find for, the death penalty, may be able to to get around the premeditation factor here and just give the defendant life in prison? I mean, it could really go either way, right?
There are two schools of thought when it comes to these cases. The first is, take the guilty plea, save the public resources, because there are mandatory appeals that come with death penalty cases. There's state and federal appeals. It's going to work its way all the way through the Tennessee courts and the federal courts. So it's going to be years, sometimes even decades, before folks are executed. So some prosecutors believe that, if an individual is willing to plead and serve the rest of his life in prison, you should accept that. Others say, no, this is why we have the death penalty. And if there was a case that is appropriate for the death penalty, this is it. An officer was murdered. So, you could really kind of go either way, but that's why you see some prosecutors in some cases accept that guilty plea and agreement to life without prison.
Right.
Life in prison without the possibility of parole.
Right. And of jurors in the courtroom listening and seeing these fellow law enforcement officers come in and testify as to how they showed up on the scene and what they saw?
Derek, it's important, and it's impossible for jurors not to be moved by this testimony. I mean, we talked about Sergeant Baker's widow being the first witness, but these officers seeing their colleague shot, burned, and they're weeping on the stand, just very, very powerful testimony. It's impossible for anyone, whether you're a juror or watching here on a law and crime, not to be moved by this testimony. I think the majority of facts are in dispute. The defense here, it's a rare murder case where they're admitting to pulling the trigger and killing the victim. So it's certainly important in many cases, probably not so much in this case, but from the prosecution's perspective, they want to present the case in a chronological fashion that makes logical sense for the jurors. And hearing the officers describe the horror when they see that their colleague has been killed, and what the steps that they took to find the body is very powerful and something that the jurors should absolutely hear.
Right. And we know from the defense's opening statement,
and the judge has, at least for now, excluded some of the evidence of Wiggins being a felon and not wanting to be arrested. So, but the jurors do have a sense of at least why the vehicle was stopped and why Wiggins and his girlfriend had a reason to at least not want to interact with law enforcement. And this is all part of the chess game here, or poker, or whatever analogy you want to use. The defense has a very bad hand here. And, I have to give them credit. They're not overplaying their hand. There's some defense attorneys that would come in and say, hey, it wasn't me, and, reasonable doubt and all that. And I think the jurors would see through that very quickly. Really, the only chance they have here is to avoid the death penalty. So I think they have a weak hand, but the defense is playing it right.
Yeah, but hard to imagine you go from a litigation consultant, Neama, getting parts of this statement or these statements stricken from the record, is that helpful to the defense?
Very helpful to the defense, but it's not going to happen. So we're dealing with the rules of evidence and hearsay here. So kind of going back to law school and the bar exam. So the issue is officers are making statements such as, Wiggins, you executed the police officer. So the defense wants to keep that out, saying that it's hearsay, it's trying to be admitted for the truth that, Wiggins executed Baker. And what the state is arguing is say, no, it's not being admitted for that purpose. It's being admitted to show the effect on the listener, right, for a non-hearsay purpose, not for the truth of the matter asserted. And because really we know that Wiggins' own statements are coming in. And how can you really determine what he is agreeing to without the officer's statement? So I understand what the defense is trying to do, but I don't expect the judge to go along with it.
Got it. All right, let's go back into the courtroom here. I mean, we've been talking about this case and how Stephen Wiggins, is pretty much admitted to killing Sergeant Daniel Baker. The question here is whether it was premeditated or not.
Derek, we are, but these jurors are used to CSI. They want to hear the DNA evidence. This is what they expect coming in. So we are going through the motions, but they have to put on the state. They have to put on this type of forensic evidence, even through one witness, because in this day and age with TV, whether it's law and crime or fictional TV, this is what jurors expect and what they want to see.
Interrogation covers a lot of ground. I'm not sure what we're getting out of it, though.
Well, Derek, John Lewin and the prosecution think that it's key evidence, and we know this because they're ending with it. You always want to end strong if you're the state. And they began with it. In both the opening before the pandemic and the reopening, if we want to call it after the pandemic, Lewin played portions of this interview. And this is when he famously flew to New Orleans to personally interview Bob Durst for 3 hours the day before the last episode of The Jinx aired. So it's not very common for prosecutors to do that, but this is a cold case that he's been living with for quite some time. And because he did so, the defense actually tried to use it as a basis to disqualify him under the attorney witness rule. So at least according to the LA District Attorney's Office, and specifically Deputy District Attorney Lewin, he thinks that this is key evidence in the case, and this is Bob Durst making admissions and trying to talk himself out of a third murder.
Interesting. Certainly something to stand in the Morris Black trial, really trying to get him to come and stand trial for the murder of Susan Berman.
Yes, no question. The level of sophistication between both Lewin and Bob Durst is very high. Very different case from Wiggins, right, where we have lots of evidence and he's making all these admissions to law enforcement. Here you have two of the best, with Bob Durst trying to talk himself away out of his third murder. And even though he knows, and Lewin told him, that he's going to face trial for the Susan Berman murder. It's a very fascinating case, really circumstantial case, but Lewin did hit one of the key pieces of evidence, one of the key pieces of direct evidence, one of the few. We have the Jinx admission, and we have that cadaver note. And he did get Bob Durst in a lie. Now Durst, in this case, in this trial, finally admitted to writing that cadaver note. Now he's going to say he was scared because he stumbled upon his best friend's body, but that is something different from what he told Lewin in 2015, and something Lewin is going to hammer during closing argument.
Right, and you get the sense of the cockiness of Robert Durst, right? That he could just stand there and kind of explain away things in the face of a prosecutor who's looking at him for another murder.
Well, that's one of the big themes in this case, and the district attorney's office wants these jurors not to like Bob Durst. That's why they're talking about shoplifting, not waiting in line. The rules don't apply to Durst, using food stamps, even though he's a millionaire. And on the defense side, on contrast, you know, they're trying to paint this image of this frail, sick old man that needs a catheter, that has cancer. So it's fascinating to see the maneuvering, the legal maneuvering by both sides here.
Absolutely. Thoughts on this? Neama, you there?
Yes, Derek, I'm here. Very effective cross-examination by Dick DeGuerin.